This is someone who is not an appointed director, but whose instructions the directors of the company are accustomed to accept and implement. And on the subject of shadow directors, here's a conversation I often have with somebody who comes to see me for my advice. And just to make this point, I'm going to use Richard with a little bit of role play to help make the point. So please step forward, Richard. We very much, thank you. We very much enjoy our role play.
Oh, we do.
And
Yes.
and if we can move the slides on a bit, thank you. There we are. That's me in action to create the mood, and that's.
You can recognise the other person as well, can't you?
Right. Well, of course, this is the first time we've met, isn't it, Richard? So here we go. Are you a director of the company, Richard?
Oh, no.
Are you a cheque signatory?
Well, yes. Yes, I'm a cheque signatory because I thought that would be a good idea for me to sign the cheques instead of the directors. And I told the directors that.
Well, Richard, in that case, there's a very good chance you're actually a director.
Really? I wasn't aware of that, Tim.
Okay, so nobody told you. Well, thank you,
No,
Richard.
No one told me that.
Okay, you can
sit down now.
You can sit down now.
Thank you.
That's very good of you. Okay. A lot of people will say that a cheque signatory is automatically a director. That isn't necessarily correct. But whether Richard actually is or isn't a shadow director would depend on all the circumstances of his relationship with the board and how a court would interpret them. It's actually quite easy to be a director without even realising it. Anybody who is a cheque signatory and not a director should take legal advice. There's only 3 exceptions to section 216, and these are given in chapter 22 of part 3 to the insolvency rules. It's where a company acquired, the first of which is where a company acquires the whole or substantially the whole of the business of an insolvent company under arrangements made by the insolvency practitioner. Creditors must be notified and notice of this arrangement must be advertised in the London Gazette. Strict timetables need to be complied with, no later than 28 days after completion, otherwise it just doesn't work. And secondly, where an individual applies for court permission to use the name in question. And again, there's a strict timetable for this. Application must be made within 7 days of the company going into liquidation. There's no contravention of the Act by that individual for a period of 6 weeks from the date of the application to the day on which the court disposes of the action, whichever is sooner. And thirdly, the court's permission isn't required where the company has been known by that name for a whole period of 12 months, ending with the date before the liquidated company went into liquidation and hasn't at any time in those 12 months been dormant. These rules apply not only when the similar name of the successor business is used by a company, but also by a person as a sole trader or in partnership. Under section 217, any person involved in the management of a company that has at any time acted on instructions given by a person whom he knew to be in contravention of section 216 is presumed, unless the contrary is shown to have done so willingly, and as such can be personally liable for the debts of the company. So watch out any nominee or front man, or of course front woman for that matter. How many times have we seen a successor company with Mrs. Smith as director, but Mr. Smith actually running the business? And I think in this case, it'd be very difficult for Mrs. Smith to deny any knowledge of all the circumstances of the case. This situation where a company goes into liquidation and then restarts in some form or another is not necessarily scrutinised carefully by the insolvency practitioner. That's not his job. There could be a gap of several months, or the director may not entirely know what he wants to do, and it's most likely it's the accountant that gets involved with the formation of the new company, and it's so easy to foresee how a director could fall into the trap of Section 216 and be blissfully unaware of the problems. The really important message is to take advice from trusted professionals who know this area of the law and work together. So often a director seems to know someone in the pub who did things in a certain way and everything was okay. The truth is, nobody really knows what all the circumstances of that particular case were, and it's impossible to make any specific comments. But as far as your clients are concerned, don't take any unnecessary risks and speak to us. Okay, so that concludes a little summary of Section 216 and 217. Leave any questions, please, to the end of our talks.